ఈరోజు మన టాపిక్ మేధో సంపత్తి హక్కులు. ఈ మేధో సంపత్తి హక్కులు అనేవి మానవ మేధస్సు నుంచి ఉద్భవించిన ఆలోచనలు, వాటి పర్యవసానంగా ఏర్పడిన వస్తువులు కానీ, పేర్లు కానీ, డిజైన్లు రాసినవి, ఇలాంటివన్నీ కూడా మేధో సంపత్తి హక్కుల కిందకే వస్తాయి. ఈ మేధో సంపత్తి యజమానులు వారి ఆలోచనలు మొదలైనవి వ్యాపార సంబంధంగా వాడడానికి, వాటి రక్షణకి ఉద్దేశించినవి ఈ మేధో సంపత్తి హక్కుల చట్టాలు. ఈ చట్టాల గురించి మనం తెలుసుకోవాలంటే తెలుగులో కంటే మనం ఇంగ్లీష్లో తెలుసుకోవడం మంచిది. సో ఎలాగంటే, ఇంటలెక్చువల్ ప్రాపర్టీ ఇన్ బేసిక్ టర్మ్స్ రిఫర్స్ టు స్పెసిఫిక్ టైప్స్ ఆఫ్ ఇంటాంజిబుల్ అసెట్స్ which have been created owing to application of one's mental faculties. The requirements for obtaining registration for intellectual properties may vary as per the types of asset under consideration. The ownership of intellectual property rights affords various rights for protection and commercialization of such assets. Intellectual property rights are classified in a universal manner across the globe. In India, specifically, the different forms of intellectual property rights are copyright, trademarks, patents, geographical indications, designs, semiconductor integrated circuit layouts, and plant varieties. Each of the aforementioned types of intellectual property rights have been discussed herein. The Copyrights Act. Copyright protects the expression of an idea rather than the idea itself. Under this act, a protection under copyright can be obtained for original literary, dramatic, musical, and artistic works, cinematograph films, and sound recordings. Interestingly, a copyright protection can also be obtained for a computer program. A copyright is an exclusive right that is granted to a person to do or authorized to carry out certain activities with regards to the copyrighted work. For example, in case of a literary, dramatic, or musical work, the owner is permitted to perform the work, make translation of such work, make adaptations of the work, etc. The Copyright Act clearly states that the author of the original work shall be the first owner of the work. Further, the owner has the right to license the copyright of their work to third parties through a written agreement. In case of published literary works, dramatical works, and artistic works, copyright protection shall be provided to such person or to a work for a term of 60 years in addition to the life of the author. Incidental to the protection awarded under a copyright, the Copyright Act also confers certain special rights on the author or the owner of the copyright work, even after assigning the work to another person, has the right to claim authorship of the work and the right to claim damages with respect to any distortion, mutilation, or modification of the author's original work in the event such distortion or any other act is damaging to the author's reputation. Then, the Trademarks Act. The Trademarks Act defines a trademark as a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others and may include shape of goods, their packaging, and combination of colors. In simpler words, a trademark provides protection for symbols, colors, shapes, words, etc., representing and relating to a good or a service. The primary requirement for registration of trademark includes that it should consist of a mark capable of distinguishing the good or service from those of others and that it is capable of graphical representation. The Trademark Act provides for absolute grounds of refusal for registration of such as the mark not having distinctive character or a mark being deceptive and confusing to the public, if a mark is hurtful to religious sentiments and the mark is offensive, scandalous, or obscure, etc., in addition to the absolute grounds of refusal, the statute also provides for relative grounds of refusal of registration. Further, India is signatory to the Madrid Protocol under which trademark can be applied for and registered internationally. However, prerequisite for filing and registering an international application in the foreign jurisdiction is that the mark needs to be first filed in India. A protection afforded from a trademark registration is imperative as it protects the brand name, logo, sound, shape, etc., and distinctively identifies the goods and services to the brand, bringing uniqueness to the mark. Also, the validity of trademark registration is for an initial period of 10 years, which can be renewed perpetually for successive period of 10 years. And then comes to the Patents Act. The patent is an intellectual property right which protects any new invention. It is an exclusive right that protects the rights of the inventor and prevents other people to authorizedly or unauthorizedly use and misappropriate the registered patent. A patent is granted for a term of 20 years from the date of filing of the application. It is important to note that the patent for a new invention is registered only if the invention is novel and original. That is, it has not been introduced in the public domain in India or anywhere in the world, is capable of industrial application, which refers to the ability of the invention to be used in an industry and is an invention that requires to employ a process of inventive steps, which is defined as the future of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, and that makes the invention obvious to a person skilled in the art under the Patents Act. The Patents Act bestows each inventor whose patent has been registered with certain rights, namely, with respect to a patent to a product, the right to prevent third parties from using, selling, making, or importing the product without prior consent, and with respect to a process for which a patent is obtained, the right to prevent third parties from using, selling, offering a product obtained from that process without the prior consent of the original inventor. Further, India is a signatory to the Patent Cooperation Treaty, which permits an applicant to file an application for registration of an international patent. Upon filing such application, an inventor can obtain patent protection in multiple countries simultaneously. And then the Design Act. The design under the Design Act means and includes only the features of shape, configuration, pattern, ornaments, or composition of lines or colors applied to any article, whether in 2 dimensions or 3-dimensional or in both forms, by any industrial process or means, whether manual, mechanical, or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye. An application for registration of an industrial design is to be made to the Controller General of Patents, Designs and Trademarks. However, a design shall only be considered for registration if it is novel and an original invention, that is, it has not been disclosed to the public anywhere in India or outside the jurisdiction of India, and it can be easily distinguished from other known designs. Furthermore, once a design is registered, the registered proprietor is afforded protection for an initial period of 10 years, which is extendable for further period of 5 years. And then comes to the geographical indications of goods. Many goods in India are widely popular owing to their place of origin. For instance, Darjeeling tea is unique and popular owing to many factors, including but not limited to its origin, the skill set of the tea farmers of Darjeeling, and the weather prevailing in that area. Other such examples of products which have bearing of the place of origin. A geographical indication is defined as an indication which identifies such goods as agricultural goods, natural goods, or manufactured goods as originating or manufactured in the territory of country or a region or a locality in the territory where a given quality, reputation, or other characteristics of such goods is essentially attributable to its geographical origin, and in case where such goods are manufactured goods, one of the activities of either the production or of processing or preparation of the goods concerned takes place in such territory, region, or locality as the case may be. The GI Act covers only goods such as agricultural goods, foodstuff, handicrafts goods, manufactured goods, and natural goods. An application for registering a good under GI Act requires a statement explaining how the geographical indication affects to the region of the good in terms of the quality, characteristics, and reputation of the good, the class of goods, particulars with regard the appearance of the geographical indication, and the map of the territory, area, country where the good has originated. A registered geographical indication is awarded protection for a term of 10 years with the option of renewing and extending such protection for a tenure of 10 years from the date of expiration of the original registration. Even the handloom textiles also given trademark. The Protection of Plant Varieties and Farmers' Rights Act is the next one. The objective of Protection of Plant Varieties and Farmers' Rights Act is to recognize rights of Indian farmers and to provide protection to plant varieties in order to encourage the growth and development of more plant varieties. And also the India became a member to the trade related aspect of intellectual property rights agreements, under which all members are required to accommodate and provide for the protection of plant varieties. All plant varieties that have been registered and awarded protection are entered and recorded in the National Register of Plant Varieties. The Plant Varieties Act permits any breeder, farmer, and any person as authorized to apply for registration of a new plant variety. A new plant variety is registrable if it is satisfying the conditions of novelty, distinctiveness, uniformity, and stability. To elaborate, the condition of novelty requires that at the date of filing of the application, the plant variety must not be sold. Further, distinctiveness encompasses the requirement of having at least one distinguishing factor from all other existing protected plant varieties. The requirement of uniformity means that all essential characteristics of the plant varieties must be uniform. Lastly, the plant variety being registered for is required to be stable, meaning that the essential characteristics of the plant variety must remain unchanged after repeated propagation of such plant variety. The validity of registration for the protection of plant variety is for a period of 9 years in case of trees and vines, and for a period of 6 years in case of crops, with the option of renewal of such registrations. Next, the Semiconductor Integrated Circuit Layout Design Act. A semiconductor integrated circuit is defined as a product having transistors and other circuitry elements which are inseparably formed on a semiconductor material or an insulating material or inside the semiconductor material and designed to perform electronic circuitry action. Under this Act, all layout designs capable of being registered are required to be original, commercially unexploited anywhere in India or in any convention countries. Inherently distinctive and inherently distinguishable from other registered layout designs. An application for registration of design layouts has to be in writing and is required to be filed before the registrar in the Semiconductor Integrated Circuit Layout Design Registry present in the territorial limits of the principal place of business of the applicant. Further, the protection afforded to registered layout designs is for a period of 10 years. In India, there are different forms of intellectual property rights allowing a person to obtain protection for their assets. India has actually become party to many conventions and treaties in order to afford international recognition and protection for intellectual property rights recognized in India. Some conventions have led India to introduce new enactments such as the Plant Variety Act in order to award protection to goods that represent the heritage, agricultural background and future in India.